can be detrimental to his life.
Yes.
His entire reputation, and being a civilian versus having a title will at least dilute the situation.
That's correct.
That's just my opinion. Now, Griggs just put out the TRO that Jayden's attorney filed. If he has a hearing, all of this embarrassing stuff is going to come out.
Correct.
I'm not trying to coerce you or anything. So basically, you were saying that you didn't want him to have a hearing because if he had a hearing, exercise his right to a hearing, all the embarrassing stuff was going to come out.
No, what I was saying is, why would you, and I'm sorry, let me say this. Again, I felt like I had a close relationship with his grandmother. Why would I? I mean, I even told her I love her, thank you, and I say it constantly. Why would I? And that's not the end of the discussion. I can read the rest of it for you. What I said to you was, why, and unfortunately, why would you have a hearing for privileges when he's still able to conduct his meetings? What I was trying to say is he's still able, a temporary injunction, to go into his office. He's still able to go to the events. He was able to come to the concerts. He's able to speak. Why would you risk putting things out there, like dealing with high school students that have pictures exchanged and all that? Why would you risk putting that out? I think I was more upset with you for malpractice. And what I said was, why would you, as an attorney or anybody else, this is me thinking, would go and try to put something out and allow people to hear about allegations, conspiracies of a high schooler or the mayor being with a high schooler or being with multiple high schoolers? Why would you do that? Because if we had a hearing and that evidence would have come out, because let's say if you went line by line trying to get his privileges back, because he was still the mayor, he still was able to do different things. Why would you do that as an attorney and bring that stuff out when we're trying to confine it so that people won't hear? Let the investigation take its course. I said it to protect Jayden. I said it because if you want can you imagine? I've had experiences like this before, conspiracy theories, where you put something out and you keep saying that a young man is having these sexual misconducts with high schoolers, and he's created a program that the council knows nothing about and did not approve. And if that got out, how many people would start coming in and saying of their experience or panicking because their child has been around the mayor? That's what I said. That's the things that I was talking about. That's what I was trying to say without having to say it, without embarrassing Ms. Thomas, without embarrassing Jayden, the person that I just talked to and joked with last week. That's what I said.
This was the first time that it has ever been divulged that there's been an allegation about the mayor and a high school student. Is that right?
What do you mean?
In public.
Yes.
But you have been insinuating that there have been some sexual allegations.
Okay.
You've been insinuating that on Facebook, right?
No.
So you've never said on Facebook.
It says sexual misconduct. The allegations were read based off of the resolution. I'm not insinuating on Facebook. What I said is, let us look at the investigation in general. Let's look at the investigation. Wait till all the evidence come out and go from there. And I didn't finish the other answer as well, sir, Mr. Kenner, because if you look here at the discussion, I said, I honestly think he should this is what I said to his grandmother. I honestly think he should let the investigation, which I meant investigator, do his job. And prior to any hearing, counsel would allow him to review the investigator's report. And he can make his decision from there. That's my thought. But just know, I wouldn't come to you if I truly wasn't concerned about how the end result could turn out. I'm sorry, I tried.
Okay. I just showed you, presented you with P3?
Yes.
All right. Do you recognize that now?
Yes, I do.
And you recognize that Facebook account?
Yes, I do.
And
Henry County, well, no. I don't know. I recognize the Henry County, Georgia, and it says Carol Pendergrass. I remember this text, yes.
right. And you were part of those Facebook streams, is that right?
Yes.
And conversations, correct?
Yes, sir.
And are you a friend? Are you friends with Miss Pendergrass?
No, I don't know her.
And how did you get on her Facebook page and start making comments about this case?
I don't know, sir. I looked at the page. Every time I wake up, it comes up. Maybe the algorithm or whatever the case may be. But I just saw it on the page. Now this is August 7th, so I don't know if it was August 7th or before that or what, but I don't know.
Well, can you look at P3? And do you recognize any posts that you may have made?
I'm sure I made, yes.
Can you look and see how many posts you made?
Let's see, one here, Jamal Parker. When I told him we were doing our job, why are you punishing us?
I'm just asking you not to read from the content, but how many times?
People will tag me and ask me a question. 3 will tag me and or whatever. 4, 5. Six. This is 7, 8. If you want me to count the lines, each line?
You
10.
You commented multiple times. Is that right?
Right.
Is that fair to say?
Right. Like, no, I did not. The answer is no, I did not. Or simple sentences.
Okay.
Or I can count the paragraphs if you want.
No. So, have you had a chance to look at the comments that you made?
I know exactly what I said.
Are those comments a fair and accurate depiction of what you said during the time that this Facebook conversation with the community was going on?
That's correct.
All right. Do you believe that anything has been deleted or modified at all?
Not unless it was edited when I typed it.
Okay. Move to admit P. I think P3.
Any objection to admission of P3?
There's you want, well, I know.
All right. Now, you.
Mr. Chairman,
I'm sorry.
I have to do the piece.
I'm sorry.
I know they submitted without objection. I
Thank
understand.
you. So, I want to direct your attention I have page 10.
Okay, which one? Yes, I'm right here.
Okay. Now, I think it starts here.
Mm-hmm.
I think it starts on the bottom.
Okay, you want, from 9, it starts on the next page.
Where it says John Bush. Actually, that's not. I'm sorry. Here it's, I'm saying that the investigator.
Yes, I have it right here.
Now, I asked you earlier if you had already made up in your mind whether the sexual misconduct allegations were true, right?
That's correct.
And you said you had not made up your mind, you still have not made up your mind.
I have not.
Okay. But in this post, what you said was, and I'll read the whole thing for the entire context. You said, I'm saying let the investigator do their job. The mayor has had trainings and have been warned several times from everyone. When the hearing takes place, we will all see whether or not the allegations are true. That's all I'm saying. When I talk about people trying to set him up, I mean constituents and their accusations and how people watch everything. Jayden knows exactly what I'm talking about. He received warnings. Those text messages on my Facebook page are just a small example of the warnings. Feel free to read a sample of the text messages and warnings I have made on 2 separate posts, one to him and his grandmother. I put them on my Facebook page and I told the reason why. And I'm going to say it one last time. Jayden Williams is not the victim. The city of Stockbridge is. So you're telling me that you have already determined that the city of Stockbridge is the victim and the mayor is not.
So you're taking it out of context if you think is that, no, that's not what I'm saying.
I'm asking you a question.
Or would you like me to explain?
Did you not say that Jayden Williams is not the victim the city of Stockbridge is?
That's exactly what I said on here.
Okay, and then you go on to say, and anyone who wants us to sweep serious allegations of misusing funds, abuse of power, and sexual misconduct under the rug because he's so young and speaks so well is an enabler,
That's
right?
correct.
So you're basically saying that anyone who disagrees with you, that there is
Objection leading, Your Honor.
have on cross.
Overall objection.
You're saying that anyone that disagrees with you about whether these allegations are true or not is an enabler.
No, that's not what I'm saying.
That's what you said, right?
No, I didn't say anyone who disagrees with me is
Okay.
an enabler. That's not what I meant.
All right, well, let's say what you
Do
said.
you want me to talk about what I said?
I will, let me finish. What you said was, the city of Stockbridge is, and anyone who wants us to sweep serious allegations of misusing funds and abuse of power and sexual misconduct under the rug because he's so young, he speaks well, is an enabler. So shame on anyone who enables. Right is right, wrong is wrong.
That's correct.
So it's your testimony that based on the statement that you gave, that you're talking to the entire community, that is not a biased statement, ma'am?
No, it's not.
Okay. Let me ask you a question.
Because it's not in that context.
All right.
You can't get tone from text, but I'll be more than happy to explain it to you.
Well, you can't
Just
put,
like I said at the very first line, I said, let the investigator do their job. The mayor has had trainings and have been warned several times. And I keep saying, all I'm saying to you guys is, let the investigator do their job. That's it. And if you don't mind, sir, in regards to what I was talking about, again, I received a phone call from Atlanta, I believe it was Atlanta News First, or one of the media outlets. And it was frustrating to hear that the text messages that I had sent, trying to warn his grandmother, were put out, that were given to the media. So before they put them out, I was very upset about it, and I wanted to explain what was going on. In addition to that, when I spoke about this, and I'm not saying shame on anybody I'm not saying Jayden committed this conduct. I said, let the investigation go on. Don't get mad at us. We've had so many people come to us, each one, just not me, everybody. Oh, and you can see it, if you read it, even on here, he's so young. Y'all didn't train him. Why didn't you help him? What I wanted to show people is that I have tried to help Jayden. I'm not saying Jayden, even to this day, I don't know whether Jayden and the accusations that have been made are true or not. I know how people put things out there. I know how rumors spread. I know how they can over-exaggerate. And because of that, I keep telling you, let the investigation go forward. And when it's presented to us on Saturday, that's when I would be willing to sit down with my colleagues and deliberate on whether or not anything violates the charter. And that's as an officer of the law, as a councilwoman, and when I said that Stockbridge is the victim, what I mean by that is the citizens, we are hurting. We're hurting because it looks like we're bickering with our mayor, and we're not. We're not. Well, he just said we are, but we are not. We're not bickering with our mayor. We sit down from each other and laugh and joke, even as of last week during the budget retreat. We haven't had bickering. The only time we're uncomfortable and don't speak and joke is when we're in a setting like this, when he's around you. Before that, we were joking when we did interviews for clerk position. I mean, we are not. It's just not true.
so y'all always been cool.
We're cool, and we have our disagreements, yes, but we are cool, and we do act cool.
Okay, I'll get to that in a few minutes. So, your testimony is that you didn't believe the allegation. You had not formed an opinion, right?
That's correct.
Now, these Facebook comments, that was August the 7th, correct?
I don't know what day, it says here August 7th, but I don't know what day it was. I
Okay.
don't know if this is from a screen on August 7th or what, but it went on and on and on. They have multiple days.
But it's after the August 5th resolution.
I don't know. Sir, honestly, what August 5th resolution? Which date did we have the investigation? Which date did we do the resolution?
Well, you don't remember?
No, if you give me the dates, I don't mind, but I don't know.
August 5th,
Okay,
all right? Did I show you this when we refresh your recollection?
yes. That's the day that we adopted the resolution? Yes, sir.
Okay. Now, and do you recall when you guys hired the investigator?
I want to say we hired an investigator 2 or 3 days after they did the resolution.
Which one?
I don't know the dates.
Well, you had 2 resolutions. You had one July 17th, right?
Okay.
And then you had the other one August 5th. So by the time August 5th had come around, you had already hired the investigator.
No, sir, I don't know about that, no.
Okay.
We didn't hire an investigator until after we made the motion on a Friday night. Then a couple of days later, I wanna say, is when an investigator hired, cause that was on a Friday. So they couldn't have hired him until like the following week.
Well, July 17th was on a Friday.
Yeah, well, whatever day it was, we didn't hire an investigator until
The next week,
the next week sometime, from my understanding.
which would have been before August the 4th.
I don't,
When some-
yes, before August.
All right.
I
Now-
can stay down, place. We have an investigator August 10th.
Well, unless you
You
want
don't
to
get to
testify.
stay in your place, the witness
Right.
must answer the question.
Okay, so I don't know the date.
All right.
I'm sorry.
Go
Okay.
ahead, Mr. Campbell.
Now, you said that the Facebook post,
Mhm.
I took that out of context, right? When I talked about sexual misconduct and that people are being an enabler, I took that out of context because you weren't really saying that the mayor was a sexual predator. You weren't saying that, right?
No.
All right. And that about people being enablers, you didn't mean it that way. Correct?
No,
All right.
so that's not what I meant about, I wasn't talking about the mayor in general. I'm talking about people are complaining as
Okay.
if we haven't trained the mayor hasn't had any training, that we don't support the mayor. In my eyes, the entire mayor and that entire council and staff have supported the mayor.
Okay, let me read from P1 that's already been introduced. And you had a conversation with Bruce Smith, is that
Yes.
right? And you talked with him on the telephone, you also texted him, is that right?
Yes,
All right, and in one of your text messages to him, and again, you're saying that you hadn't formed an opinion about whether these sexual allegations were true, is that what
That's
you're saying?
correct.
And you still have not formed an opinion,
No, I
right?
have not.
All right. In this text message, you said, we can't let the mayor do his initiatives. He doesn't need to be around minors, as far as I'm concerned.
okay.
So,
And I also said let everything sort out.
okay. But as far as you're concerned, he doesn't need to be around minors, but he has not been charged with any type of sexual act, has he?
That's correct.
He has not been arrested on any type of sexual act.
Not at all, thank God.
As a matter of fact, the police report that we're talking about was in February of 2025.
No,
Are you sure about that?
no, this police report was not in February 2025.
When was
This
it?
is in regards to the mayor, February of 2026. And the reason why I
I'm
know
sorry.
that.
I misspoke. It was February 26th.
Yes,
All right. You understand that that investigation had nothing to do with the mayor.
no.
You don't
I don't
understand that?
understand that, no.
But you said folks came into the session,
Mm-hmm,
pulled up the police report or so, incident report on the screen, right?
mm-hmm.
Is that yes?
Yes, they talked about it, I don't know if it was, well, I was such, after that, we were ready, after talking and giving us the facts, or summary of facts, I think we were all shocked to hear of some of the allegations.
Oh, well, so many. There was only one. We're talking about the police report,
Okay?
right? So one.
No, it was more allegations, but
Wait
just
a
the
minute,
police
wait
report.
a minute. The police report had nothing to do with any type of sexual allegation towards the mayor, did it?
No, not towards the mayor had made sexual allegations, it was allegations of sexual misconduct between the mayor and the 11th, they said he was in 11th grade, and that there were photos,
Now, my
and
question.
screenshots of text messages, that's what I heard.
My question to you, not what you heard, talking about what you saw. You understand that there is no investigation or so, or any arrest surrounding any type of sexual misconduct as it relates to the mayor.
I don't know that, sir.
Okay. you spoke with in session all the other council people. You had the finance person came in there. Your council was trying to say that the police officers were in there. There were people in there that talked about the police report, right?
Yes,
And this was in July.
yes, when, the night we did the investigation, we moved for investigation, yes.
Right. So in July, you guys are talking about a police report that was generated in February of the same year, of 2026, right?
I don't know when it was generated. All I know is, from my understanding, there was something that took place in February 2026, and they mentioned, I don't wanna get caught up on dates, again, I don't have the dates in front of me, but it was in 2026 when the mayor became the mayor, when the mayor was the mayor. And the concern was because the young man wanted to be a part of the mayor's mentor program. That's all I know. It was affiliated, it was enough information for us to be concerned because it was affiliated with the city of Stockbridge and the mayor's initiative.
Well,
That's all I know.
But you understand. Are you familiar with the mayor's mentorship program?
Not really, somewhat,
All right.
but
And
not really.
you understand that there are individuals in the program that have to go through the city and be vetted and things of that nature. You understand that, right?
Well, if we approved the program, if we approved it, then it depends. It depends. I know when we do committees, certain committees, they have to do a background check. And if there was some kind of board or committee, they would have to do a background check. And just like the Stockbridge Council, advisory boards, and different things like that. But I'm not familiar with the mayor's program, so I can't say what. But when I say I'm not familiar, we didn't approve a program.
You understand that this individual is not listed as any person or individual associated with that program.
Again, the city doesn't, as far as I'm concerned, the city doesn't have a program that we approved, sir.
We're talking about the mayor's initiative program.
I don't know, he would have to answer that.
Okay, well, you said that we have to suspend his initiatives. He doesn't need to be around minors as far as I'm concerned.
That's correct.
So you had already concluded in your mind that, based on the allegations, mere allegations,
Okay?
right? You had already concluded that he doesn't need to be around children.
No, that's not what I concluded. Why? The reason why is because of the protection of Stockbridge. When there is an alert, just as that, of sexual misconduct with a minor or with a high school student, whether he's 18, I don't care, and then there's some kind of inappropriateness to it, we have to act. Otherwise, we could be liable, sir.
Well,
That's like why would I protect the city? I took an oath to protect the city. I'm just trying to figure out at what point do we not try to stop any type of emergency just in case it's an emergency. I don't know if it is or not. All I'm saying is I know how politics work. And I know that the conspiracies would start, and the minute that we hear something like that, and there's a police report involved, we have no choice but to act. And that's what we did. We acted out of caution, not saying that he's guilty or not guilty or what. And guess what? It may not be anything. It may be that none of this happened, or they were lying, or they wanted to set him up, or whatever the case may be. It may not be. Again, every single time I said, please, everybody, let the investigator finish doing their job. And that, sir, is why I was so upset and couldn't believe that you did what you did. Because I didn't want to be here. I didn't think that we should be here. I was, honestly, Jayden, I was trying to protect you.
let me ask you this. You understand that based on that police report, and you've spoken with the police chief, right? About this case.
Who?
The police chief.
No.
You haven't spoken with any police officers regarding that incident report, man?
I haven't talked to the officers about the police report, no.
Okay, have you spoken with anyone about the police report?
About the what?
The police report.
No, I asked the city manager for clarification when we were in the investigative room. I have not asked any police, listen, we don't want,
Ma'am,
we didn't want this. No, I have not,
All right.
no.
You understand that there is a closed, in other words, any type of closed, there's a closed investigation. The investigation is closed
Okay,
as it relates to any allegation of sexual misconduct involving the mayor. You understand those?
no, I don't. I don't know. I know that the investigation was closed, something about, I don't know. I
So
don't
you don't
know.
know.
But let me tell you what I know.
Wait a minute,
I know
wait
what I
a
gave
minute.
you earlier.
Wait.
That's it.
Okay, you don't know, but you're out here in the public talking about sexual misconduct, sweeping it under the rug, people being enablers, and right is right and wrong is wrong.
Yes.
But you don't know.
Right is wrong.
You understand that as a councilwoman, you have an obligation to make sure that you're a professional at all times,
Yes,
right?
that's correct.
And do you think that as a councilwoman, and this is August the 7th, so you already knew that you were going to be presiding over any type of hearing and will be making, you'll be one of the decision makers whether he should be removed. You knew that by August the 7th, didn't you?
Sir, yes, if it was the date
Okay.
that we actually, if
Okay.
that's the date,
All right.
then
Well,
I don't know if that's the original date or
well,
not.
the resolution says August the 5th.
I understand that, but I don't know the original dates of the other things, and in addition to that, sir, is nothing that I haven't repeated constantly before.
This resolution says August the 5th. It goes on to talk about what's going to be, what the allegations are in the statement, the charges, right?
Mhm.
You read the charges as a councilwoman.
Mm-hmm.
You also read the resolution, correct?
Yes, correct.
Okay. Now, this was August the 5th. That conversation was August the 7th.
I don't know which dates the conversations were.
Okay.
Again,
Now,
I don't recall. However, I saw the date that you have here for August 7th. I don't know which date that it originally published, sir.
but you understood by August the 5th, ma'am, speaking with the city attorney, that you were going to be one of the arbiters,
Yes,
one
sir.
of the decision makers.
Yes, sir.
And whether he should be removed. You knew that by August 7th at least, right?
I'm assuming so, yes.
But you were still making comments about his P card, about his vehicle. You even put up communications, text messages between you and the mayor, where you told the public, I tried to warn him, and these are the receipts.
Those are not, that was before that. I think these are just repetitive. What you don't understand is, I did a video. What I believe in is being as transparent as we could, as I can, after receiving numerous amounts of phone calls, after looking at this, and everybody coming up with conspiracy theories. Again, every single time I've said, please just let the investigator do their job. And I am telling you, in your honor, I'm telling you that all I want to do is see the evidence. I have tried to protect from getting and becoming a tsunami or a circus. What I did not want to happen was we put out information like this and people hear it and then they start talking about their experiences that they have. And God forbid it's not. But can you imagine being in my shoes where I have to sit here and I'm trying to dilute what could become a circus, and it becomes a circus? That's what I tried to do.
Let me ask you something. The receipts that you were talking about, those receipts are text messages, correct?
I don't know which receipts.
Well, you.
Oh, yes,
So
they're
you-
text messages.
So you were saying, I have receipts.
Receipts of my conversations with the mayor and with his grandmother for years.
No. We're talking.
For years.
We're talking about the receipts. We're talking about. It was in relation to the vehicle, where you talked about in these communications about you talking to him about the vehicle, the county car.
Which one are you referring to?
Well, the receipts, because you posted the receipts in this
Talking
communication.
about the screenshots of me talking
Yes,
about
you
the vehicle?
right.
Yes.
And you posted the text messages between you and the mayor where you're talking to him about the vehicle.
Yes.
Right? And you understand that one of the charges one of the allegations in the charge is concerning the vehicle.
Yes.
But you,
Well, I don't know if this is concern, I don't know if that's one of the allegations, but the attorney can let me know that. There was a lot.
So you don't know?
There's a list of them. If it is, then part of it, then yes. There's a list.
is your testimony, ma'am, have you seen the charges?
Yes.
Okay. Is your testimony that one of the charges or several of the charges not have anything to do with the vehicle?
I'm sorry. Yes, if it says it on here again,
Okay.
that's not what I'm saying. If it says, yes, if it says something about the vehicle, but I don't know if it says.
But you're talking to the public about charges that are contained as early as, or so as August, well, as early as July 17th, because those same allegations are contained in the July 17th charges about the car, right?
I'm confused with what you're saying, but to answer your question in regards to a vehicle, there are some allegations in regards to the vehicle on here.
And you're talking about those same allegations, right?
Does it, if you can see, if you can point to.
Ma'am, I just asked you a simple
Well, I need to read it.
No, you.
But misuse and unauthorized retention of city vehicles and related property. Yes.
All right. So, as an arbiter, you had already been chosen or determined that you were going to be an arbiter, one of the arbiters or decision makers, and one of the issues or allegations concerns the vehicle. That you're going to sit as an arbiter in the decision making to decide whether he committed that violation or not, right?
That's correct.
Right. But you are on Facebook talking about the very same charge, or one of the charges, that you're going to have to preside over and make a determination about. And you're saying you have receipts.
Let me say this, the receipts were what I posted, what you have, correct? And let me also say that in regards to the allegations of letting somebody else drive a vehicle, I was just trying to show where they're constantly saying that nobody's trying to mentor or help Jayden, and I've tried several times. He's asked me questions, I'll feed it back to him, that I have tried to help. I'm not saying he's guilty, I'm not saying he's innocent, and I don't know what this.
Well, you already say he's guilty.
No, sir.
Because
No, sir, I have not. But not only that, in regards to the post, I was responding to Atlanta News First because someone was giving them the text messages. So I wanted an opportunity to explain what was actually going on. And even then, I said, all I want y'all to do is chill out, basically, and let the investigator finish their job. That's it. That's it.
Okay. Let me ask you this question. Do you recall on April the 7th, 2026, having a text messages, email between you and the mayor? And I believe you copied other council people, as well as, I believe it was Sean Edmondson, he's the
City manager.
Rosalind Rawls,
Yes.
Cassandra Lester.
Yes.
I'm gonna show you what's been marked as P4, identified as P4.
Okay.
Can you read that to yourself?
I'd like to see what you and my client.
I'm sorry.
Okay.
Let me let council see. describe for the court what you are being shown.
Yes, well, let me read it real quick, because we've had a lot of things. Yes, I would call this message.
Okay. Is that a message or is that an email?
I mean, this is the email.
And that is an email from whom to whom?
This is an email from me to the mayor.
Okay. And that email is dated when?
April 7, 2026 at 9:38 a.m.
Okay. Does that email appear to be what you wrote at the time on that day? Contents, or does it seem that anything?
Yes, this is exactly what I said.
Okay. And was there a response to what you said to the mayor from the mayor?
I don't see one. Wait, yes, there is.
Okay. Is there also a response from what you said to the mayor from one of the councilwomen? I believe it was Councilwoman Barber.
Let me find it. I'm sure it is. Yes,
All right.
but I don't see. Okay, yes.
Is that email and the contents contained therein a fair description of what you wrote and what was said back to you in April?
Yes.
Move to admit, I believe P4, Your Honor?
Any objection?
Yes, Your Honor, I object to the relevance. A set of April emails about matters that are not, there's not a logical nexus between emails between council members in April and something that happened in July and August as part of a TRO that's an amendment that we're trying to make a decision about. I don't know how to go.
Well, Your Honor, she testified that she had a great relationship with the mayor and that the relationship has always been good. And that email goes to not so great relationship. And it goes to motive as well as bias.
I overrule the objection, submitted over objection.
Now, you wrote an email, you started off, you wrote an email to the mayor, right?
I did.
What time was that email?
That email was 9:38 a.m.
Can you read what you wrote to the mayor?
Yes, I can. Mayor Jayden Williams, please be mindful and very selective on how you say things. Saying we're the blackest city, even if you were adding onto a joke, was unacceptable. Tell the people that you try to appease about Lee Street on the side that I was trying to say we are the blackest city. In other words, stop being two-faced. For some reason, you really believe you are clever and smart. Please be mindful of the wisdom in this council. Nothing gets over our heads. We are never surprised and shocked. We expect and hear of your comments and backstabbing ways. It's not time to say anything or do anything about it. This is your final warning, and reset with me. I came to you because we see how petty you're being about pictures. Your approach to wanting us to stand below you. Try me again and see how far you go. I mean that. Lastly, if you ever allude to or represent as if you have any power to negotiate a contract or do anything on this council's behalf, I will make a motion to censure you and publicly speak of your previous behaviors myself. I don't go around being childish and petty and talking about you to other people. tell you to your face, if I get any wild wind again that you're lying, causing a divide, walking around here abusing power for self-gratification, letting others drive our vehicles, anything, I will deal with it myself. This is an extended olive branch. Please make sure you speak when coming into our events as well. The public doesn't have to know I don't like your behavior. That is something I don't do. If I have one or any person tell me you said something negative about me or anyone else on this council or staff, I'm going to personally handle it. That is a hard reset, a very hard reset. I can be your friend or your enemy, your choice.
But that was your way of chastising the mayor.
No,
You weren't?
it wasn't. Let me tell you what my way of what I did
Was
after
that
that.
free?
We were just joking last week. The mayor has come to me and said things as well. He didn't like that I spoke, and I respect that. He said that I'm not his child. He's not my child, or something to that degree. The mayor,
Okay.
I've been talking to the mayor since January,
All right, hold on.
coaching,
Wait a minute.
helping.
Let's stay on track. Let's stay on
Okay.
track. Read what the mayor said to you.
Great morning, all. This is April 7, 2026, 9:58 a.m. Great morning, all. This narrative is not accurate. First, don't need to believe I'm smart. I know who I am and what I bring. What I do expect is mutual respect if we are going to operate as a team. On the comment you referenced, I understand how that could have been received, and I will be mindful of how things are said publicly. That said, there was no intent to divide, offend, or present anything in a way that contradicts my public position. Let's also be clear, I have not spoken negatively about any member of this council or staff. I don't operate in back channels or engage in division. If there are concerns, I address them directly and professionally because at the end of the day, we are a team. Regarding the photo situation, that has been mischaracterized. I did not seek out a photo. The individual approached me and said, let me take a photo with my mayor. Nothing more or less. In regards to speaking during the event, that was discussed with everyone based on older team requests. We were to stand on the ground and speak due to the DJ equipment setup. It changed on the spot, and I asked each present member to join me on stage by name so everyone can know who joined us from Team Stockbridge, not to be elevated above. On the issue of authority, I have never represented myself as having the power to negotiate contracts or act on behalf of council in that capacity. When I contacted, I immediately passed the information to the city manager, who had been fully aware and has handled those communications appropriately. As it relates to events, I will always show up, speak, and represent the city with professionalism. That has never been in question. Now, I want to be equally clear. Threats, ultimatums, or framing this as friend or enemy is not how I operate. I'm here to lead, to collaborate, and to move the city forward. That requires professionalism and respect on all sides.
Okay. Now, he tried to tone it down, right?
Mhm.
Tense it down, correct? And he didn't come back and call you any names or say anything derogatory about you, didn't tell you that you need to watch your mouth or who you think you are. He didn't do any of that, did he?
No.
As a matter of fact, you sent him an email, and whatever someone told you about what the mayor may have said about contracts and things, you believed it, didn't you?
At the time, yes.
Right. Before you even called him and asked him the question. Right?
That's correct.
So all you had to do was just pick up the phone and call the mayor and say, hey, I'm getting this information. Is this true? You never did that, did you?
No, I've spoken to the mayor several times
Wait a minute.
on different ones. I don't know if I talked to him about that, but
Wait a minute. We're talking about that evening.
I don't recall. But I'm telling you that when I talk to the mayor, it's about several subjects.
We're not talking about several subjects.
I don't recall
We're
if
talking
it was
about the
part of
fact
that or
that
not.
there were allegations made
Mm-hmm.
that you believed, and you believed it as such that you sent out an email that you named, you had other folks, other professionals on that email chain accusing him of something that he didn't even do. Instead of just asking him, you could have just asked him, right? Could you not ask him?
I want to say that I don't know whether or not I asked him or not. I've had so many conversations with the mayor.
All right, keep reading. What did Councilwoman Barber say?
Am I supposed to read what Councilwoman Barber said?
Yes. It's in evidence. Go ahead.
Okay. I am deeply troubled by the apparent threats made by a council member against the mayor in the series of emails below. As a member of the governing body, I feel that I have a duty to report this, otherwise it will appear as if I condone this type of behavior. And on that, it was CC with Sheriff Scandrick, Richard Godfrey, which is one of our police officers, one of our assistant chief, and the rest of mayor and council.
And what was your response?
Your statements are inaccurate. I have the evidence and the witnesses that no, I will not be giving to you, but will use them if I ever need to. Again, this is my final reset.
Did you say anything else?
It doesn't look like, this is April 7th, 10:33:51. April 7th is the one I just read to you, 10:48 a.m. And this is 10:33, it went backwards. And then at 12:11, I said, today's event being the blackest. See below, any names were taken off. This is not a threat. This is what I do. I'm tired of the nonsense. Work together or stand down. That's what I said.
So who were you telling to stand down?
I told the mayor, work together or stand down, and that included the whole mayor and council, because I'm tired of the nonsense.
After he had already sent you an email saying that he wanted to keep this professional, he wanted everybody to be cohesive, you still sent him in response an email saying, work together, stand down.
Yeah, it wasn't a response to him. I don't think it was. It was a response to what Councilwoman Barber said. And in addition to that, I don't think so.
You sure about that?
Well, that's what it looks like. It looks like Councilwoman Barber, I don't see anything different from that. I see where, on July 23rd, he forwarded to you this email, but that's it. It was Councilwoman Barber, and then I wrote this, and I said, work together or stand down. And the reason why I did that is because since January, I've talked to the mayor. I talked to him before he was the mayor. We've had candid discussions. I called him. You know why I called him? I apologize because at one point I asked him, why do you want to run for mayor? The mayor doesn't have power. Run for the city council seat. And then after that, we talked about it. And then I came and apologized and said, you know what? Do what you dreamed of, my bad. I'm here. We're standing down with you. We are going to support you. And in addition to that,
Can I ask you a question?
in addition to that,
I didn't ask you a
okay?
question.
Yes.
Let me ask you this. The police report was regarding a burglary, regarding another individual. Is that right?
Yes.
All right. Had nothing to do with the mayor.
No, it had some stuff to do with the mayor.
All right, wait a minute. Burglary didn't have anything to do
No, the burglar did not, from my understanding, but I don't know.
Okay. Now let me ask you this question. This incident, I believe the text messages that you're talking about between the mayor, you're saying there were some text messages or whatever, communication between the mayor and an individual. That was before the mayor became the mayor, right?
I don't know. Again, sir, we were given a summary. We were given a summary of the alleged allegations and the concerns.
So you're testifying under oath that you don't know whether those communications between the mayor, or alleged between the mayor and this individual, who was an adult, by the way, happened before he became the mayor? Is that
It's from my understanding this was during when he was the mayor. That's what was told to me.
Okay.
That's what, from my understanding, these things took place in the transition of him becoming the mayor and when he became the mayor. I don't know the difference, but he was the mayor. He was the mayor in February, and that's something that was definitely, I remember February 2026.
Okay. Now, and I'm almost finished. You recall, you know a person by the name of Emmanuel Jones?
Yes,
How do you know Emmanuel Jones?
he's our senator. He's still our senator. Well, I don't know if he's our senator. He's one of the senators here in Stockbridge.
You know him well?
I know him well enough.
Okay. You have had conversations with Emmanuel Jones regarding the mayor, haven't you?
Recently?
Yes.
Yes.
Okay. As a matter of fact, you talked with Emmanuel Jones last Friday.
Yes, he called us in we were in city council budget retreat.
Right.
Yes.
And what was the communication?
The communication was, he's basically tired of this,
What was your communication now to him?
my communication with him?
Yes. What did you say to him during that?
I-
Well, let me
when he
ask you.
called us?
Let me ask you this. Straight. And I just beat to the point.
Okay.
It was you and Councilman
Alexander.
Alexander, correct?
Yes, that's correct.
You and Councilman Alexander had a conversation with Emmanuel Jones regarding the investigation and the allegations surrounding the mayor. Is that correct?
No,
Yes,
that's
sir.
not, well, the whole council did, that was there. The council that was
Wait a minute,
arraigned,
wait a minute.
that was there, had a conversation, because I came back with the phone on speaker.
All right, well, the only other individual was there, besides you and Councilman Alexander, was Councilman Clyde.
Okay,
All right, so it's the three of you.
okay.
So the three of you,
And Mr. Edmondson and legal team.
all right, oh, so the city manager, as well as, who's the legal team?
I think it was Megan, a part of Quentin Washington's team that was president.
Was this gentleman here, up there as well? Mr.
I don't
Ash,
know.
Robert Ash?
No.
Did he go back in session and talk as well?
No,
As a matter of fact, Mr. Ash is the presenter. He's going to be the presenter for the
Okay.
hearing, correct?
yes,
And you read the resolution, as well as the resolution regarding his position and what he will be, his involvement, is right?
yes, he's the presenter of the evidence.
Have you had any conversations with Mr. Ash regarding the allegations surrounding the mayor?
No,
Never talked to him about it?
no,
Okay. Now, let's get back to State Representative
okay.
Emmanuel Jones. He called you on your cell phone?
He called me on my cell phone.
Okay. And he had some concerns about all of the allegations and investigation and
And I
everything.
am going to object because at this point, council is putting facts, not knowing the evidence, to be hearsay because Emmanuel Jones is not here.
Alright.
So the predicate that he's using is someone
Okay.
telling him something to then ask a
I'll switch
question
it up.
about.
I'll change it. Let me ask you this question. You talked with him, right?
I've talked to him on several occasions,
And?
not about this in general, but yes.
But you may not have talked with him on several occasions about this. But last Friday, you and Elton Alexander
Mhm.
spoke with Emmanuel Jones regarding the investigation and allegations of the mayor. Yes or no?
No, that's not what we did, no. He called me. Senator Jones spoke to us. And what he was saying is he's basically, well, I can't say what he said, but no, we did not. If your question is to me, whether or not I got Senator Jones involved, absolutely not.
That's not what I asked.
Okay.
Isn't it true that you told Senator Jones about the sexual allegations involving the mayor? Yes or no?
No, it's sexual misconduct. That's what it says, it's already out there, he said it.
Isn't it true that you told Senator Jones that the mayor had a lot of guys coming to the office and that he was trying to seduce them.
No,
And
absolutely not,
And I
no.
object to this line of questioning again, because I don't know how counsel can say what somebody who's not here in court
No, I'm
has
saying what she said.
to be able to then ask her a question about what she said from somebody who's not here in court.
No. I'm talking about what she said to him.
But
I'll do the objection.
Okay, no,
Alright, so remember, counsel, and you, I know.
I do.
Alright, tell us, and be very specific, what about any allegation or investigation did you tell Emmanuel Jones concerning that?
I don't recall, but all he said, he said something about the P card.
No, we're not talking about what he said.
Let me stop you. The question does not call for any information from Emmanuel Jones. The
Oh,
question is, what information did you provide during that conversation, specifically about sexual allegations involving the man? So it's you that's speaking, that is the question.
okay. We weren't talking about that, sir. That's not what we said.
My question is, what what statements did you make to Emmanuel Jones concerning any type of sexual allegation or any allegation regarding the investigation going on with Mr. Mayor?
So.
What you said.
I don't know what I said, because I'm telling you that when he contacted us, he was saying that I can't say what he said. It's hard for me to go through the conversation without saying it. But what I said was, here's the full mayor and council. Here's the rest of us, we are here in executive session. Senator Emmanuel Jones was the one who was talking. He was the one that said,
I asked you about what you said.
the state delegation.
Okay, once again, no one is asking you to say
What he
what the
said.
senator said.
Yeah, that's it.
This is not as difficult. The question is very simple. What did you say? And if you did, what did you say? And you continue to try to get to what somebody else is saying, but nobody's asking you that question.
Okay, no, I'm sorry. It's hard to do that when I'm trying to say, I didn't talk much. Senator Jones did the talking.
Okay, so then that answers the question. Ask the next question.
Okay. After, you are aware that after you and Elton Alexander and Councilman Cloud spoke with Emmanuel Jones, that there was a letter that was sent to the governor.
Yes.
Do you think that had anything to do with you and your conversation with Emmanuel Jones?
objection
No.
causes speculation.
I asked her a question.
I'll sustain the objection, and I'll strike that question and the answer from the record.
Okay.
Ask the next question.
All right. I'm going to show you what's been marked as P5. Without getting into the content, can you tell the court what you're looking at?
I'm looking at your formal request for recusal.
Okay. When is that dated, ma'am?
August 14th, 2026.
August 14th?
Yes.
Okay. That was the same day that you had a conversation with Emmanuel Jones, right?
If that's on Friday, then he contacted us on that date, yes.
Okay. So you received from me, from my office, a request for you to recuse yourself based on my assertion that you have prejudged this case and that you're biased and that you're not qualified to be a decision maker on whether the mayor should be removed. Is that essentially what I said?
Yes.
I also sent you some text messages from that you sent to the mayor's grandmother as well as to Bruce Jones. And I think I also sent you the email string based on communications that you made. Is that true?
You know, I don't see an email here, but I don't see the full text message. You just put some bullet point proofs of, I guess, lines that you were concerned about, but it's not in the full text message. They are, the full text messages are now part of the exhibits, yes.
Okay. And did you ever respond? Did I give you a deadline that I was at?
You did.
And
You
what-
gave me a deadline of, I think I saw it in here. There was.
Was it Saturday by noon?
I'm looking for dates.
Well, it's Saturday by noon, the next day.
No, I don't see that.
Well,
Uh,
let me see if I can show it. I can see it.
okay. August 17th. So, I believe 2 days after.
Did you ever respond?
No.
Do you intend to recuse yourself?
Not right now, no.
When you say not right now, what do you mean by that?
Because I don't have a reason to recuse myself. I feel like I can be fair and impartial. I feel like I've said over and over again, please let the investigation take its course.
Let me ask you a question. If this were you, and you were being summoned before a board that you believe based on comments, text messages, emails, Facebook posts, would you want that person that was making these type of allegations or assertions or comments, would you want that person to preside over a matter that you thought was very serious?
Your Honor, I object, this is called the ultimate issue.
I'm just asking her a question.
Same objection. Ask the next question.
All right. You honestly think that you are fair and impartial, correct?
I do.
Right. Even with all the comments and text messages, even with the emails where you're basically, some would say that you're threatening the mayor.
Yes, I do. Because the truth is, I care about this city. I care about the mayor. I put it even in Bruce Smith or whatever, that I care about all of us, even people that I don't get along with. What I did not want was a spectacle. And what I also did, and I was more upset, again, I was more upset at what you were doing, sir, than anybody.
I was doing my job.
I thought you were doing malpractice.
Well,
Mr. Gabbard, that's not counsel.
I understand that. Let me ask you this question. You made a comment one time before when the city failed and violated the charter, when you all did not serve the mayor, but yet you set a hearing date on a Saturday at 5 o'clock in the evening. And once you learned that you failed to serve the mayor pursuant to the charter, you said he was told about it orally. You remember that comment?
I don't know what I said, if he was told about it. We talked about it orally.
Right.
We were all together orally. He, the mayor, actually agreed on the date. And I don't know which one that is, but whatever the situation was, and I don't quote me on the dates. We were trying to decide on a date, and the mayor was saying something about he would just be getting back into town
Let me
or
ask you,
something to that degree.
let me just ask you. You understand the charter requires written notice, right?
Well, I don't know, sir. At the time, let me just say this. At the time, I wasn't looking at what the charter required for notice. That's our attorney's job. Now, in regards to notice, we were all at the table together, including the mayor.
All right.
In regard,
Okay.
and let me say, I'm not complaining about that, sir.
You violated the charter by not giving him
Objection, Your
proper
Honor,
notice.
that's a legal conclusion, it's not the attorney.
Response.
I mean, the charter is what it is. I mean, that's what they go by. The charter says,
Substance of that question for this hearing.
well, it goes to the fact that she wants to be an arbitrator and wants to be fair, but she's violating her own charter.
I'll sustain the objection. Ask your next question.
Okay. Do you know what the ambassador program is?
Not really, but he, yes and no, no, not really, no.
Okay.
No,
Do you understand that these individuals who are part of the ambassador program have to go directly through Ms. Rouse?
no,
You didn't know that?
no,
Did you know that Ms. Rouse had a list of names of all individuals that go through that program with the mayor?
no. We never approved the program.
I think I'm almost finished. Once you receive my letter or so, asking to recuse yourself, maybe prior to that, isn't it true that you started deleting a lot of your posts on Facebook?
No,
You didn't delete any of them?
I don't know what I deleted. If I deleted something, it was not the intention to hide or whatever the case may be. I can't say that, but no, that's not the reason why, no. If I did delete something, it wasn't the reason why.
Okay, well, I just want to make sure I understand.
Mm-hmm.
As it relates to comments that you had already made regarding the mayor and involving the investigation, whatever those comments were regarding him, you deleted many of those comments, didn't you?
No,
So you didn't delete any?
no, not that I'm aware of. I don't know if I deleted something that wasn't intended on being there, or if I deleted something, but no, I did not.
Did anybody tell you to delete?
No,
Okay. Do you understand that there is no program that's called ambassador program associated with the mayor?
I don't know what the program is called. All I know is there's either a mentor program, ambassador program. I don't know, sir. There's some kind of mayor initiative, or whatever the case may be. There is some program with children. I don't know.
Did you ever just pick up the phone or go into a room with the mayor and say, hey, these are some allegations going on, there's serious allegations, let's talk about it? Yes or no? Did you ever do that?
Okay. That's a hard question to answer, because it's not just a yes or no.
My question is, when you got these allegations were
But Your Honor, I'm gonna object. Can't she just answer where she is from?
She, and you are well familiar, Ms. Washington. First she answers, then she explains. And
What?
Councilwoman Gans has told her several times that she's not sure of the court, so she also knows that you answer first and then you explain. So yes or no, and then you explain.
Right.
So my question to you is,
Let me just, to clarify, she said what she said, which is a yes and no, and then she should be able to follow her answer.
You didn't answer the question yet, so let's have her answer the question and then seek to explain the answer.
my question, ma'am, is when you receive these allegations regarding sexual misconduct, because you were concerned, and you said that you had a relationship with the mayor,
Yes.
that you could talk to him and you guys laughed and all that kind of stuff, you understood that these were serious allegations, right?
Yes.
Did you ever say, let me go to the mayor and ask him about these allegations, everything, to see if they were true before you started sending text messages to people saying, I wouldn't want my child or children around him? Did you ever do that? Yes or no?
No, but I went to his grandmother, and I talked to his father.
Why not go to him?
Well, because I went to him several times before, sir, and I don't know whether or not these things are true or not. But I've said over and over, Jayden, let's talk about it. Why are they, so-and-so, staff members are fussing? Jayden, what is going on? I called him, I was at work, I called him and tried to coach him. Hey, we could get sued for this. Jayden, please stop doing these things.
Let me ask you this question.
Over and over and over again. And I'm not saying that it's true or not. Let's be very clear. I'm saying,
Let me ask you a question.
yes,
You also, in one of the text messages to, I believe, to Mr. Smith, you said that GMA, what's GMA?
Georgia Municipal Associations.
You said that they told you to suspend the.
Your Honor, Jack, he's trying to enter hearsay evidence because he's talking about what GMA said, which is not here to be able to be cross-examined.
Okay, fine.
Your Honor, this goes to, again, her mental state, her bias, because this, she said to Mr. Smith.
Is the statement you're listening, the statement
It's already in evidence.
messages?
Yes.
Okay, I'll allow her to answer the question.
Okay.
And once you ask her to clarify and move into hearsay, we'll start back.
Yes. You told Mr. Smith that GMA told you all to suspend the mayor. Is that correct?
Actually, I did say it, but that's what I was trying to say is we were advised, our council advised us that they spoke with GMA. And that's where they spoke with GMA.
Discussion about what counsel
Oh,
said.
that's right, I'm sorry.
Your witnesses who is proffering that information, that question was not asked. She simply asked about the text message, and witnesses are one that's now seeking to put the hearsay information in. Nonetheless, to the extent that the question goes beyond what is already in evidence, and I would sustain that objection.
Finally, Councilwoman Williams, I'm showing you the resolution or the procedures, right, for how the hearing is supposed to be conducted. You see that?
Yes.
Have you seen that document before that basically details how the proceedings are supposed to be conducted? You seen that before?
They were trying to go over all of these things with us, but we actually, oh, okay.
The question
Yes.
is, have you seen it?
Yes,
before?
we've had this.
Okay.
Next question.
You understand that there is a section, I believe this was the paragraph, 9,
Yes.
all right? And what does paragraph 9 say?
Recuse and ex parte communication. Any councilman who is.
Same kind of fact.
Oh. Recusal and ex parte communications. Any councilman who is disqualifying personal or financial interest has prejudged the merits or cannot fairly impartially decide the matter based solely upon the hearing record shall disclose the issue and determine whether recusal is required under applicable law and the adopted hearing procedures. Mayor Williams, his counsel, the attorney presenting the charges, witnesses, council members, city employees, and persons acting on their behalf shall not engage in substantive ex parte communications with the hearing officer or any participating council member concerning the merits of the charges. Procedural communications concerning scheduling, logistics, subpoenas, or exchange of materials shall be directed through the office of the city attorney and contemporaneously copied to all council.
So I just want to focus on the part about recusal.
Okay.
You've seen the charter, right? You read the charter. You're councilwoman. You've been councilwoman.
Yes,
How long you been councilwoman?
13 years.
And you've read the charter, right?
Yes,
You understand the charter?
yes.
You didn't understand the charter, it said 10 days, after written notice?
No, it wasn't that I didn't understand the charter. I knew it was 10 days, but I didn't know whether or not it was written notice or what was required. I have to go back and refer to the charter. This is not some norm.
Right. Is there anything addresses what happens in an event where a council person is going to be an arbiter or deciding factor when it relates to removing a mayor, if that person is biased or doesn't prejudge.
Not that I'm aware of.
Okay. Is there anything procedurally that's in the document that you're looking at, right?
Mm-hmm.
It can either be the resolution or where it details out the proceedings and procedures. Is there anything in there that addresses a situation where a council person who is presumed to be, or there's allegations of being biased
Mm-hmm.
or prejudged, how does the charter or how does the city address that issue?
Well, it says
If I
that.
may object here, and I know there's a unique objection, but in this role, she's Councilwoman Gant, not Attorney Gant, and he's asking for a legal conclusion from her in that matter. And that's beyond her scope of understanding.
Your Honor, she's a councilwoman, she's been in 13 years, she says she's familiar with the charter. I'm just asking her, what's in the charter that addresses that issue? This is germane to why we're here.
I don't really object, I'll allow her to answer if she knows.
I don't know of anything in the charter. I've already answered that. In this first paragraph, it just, the recusal on ex parte communications, it lists the procedures here, the one you just had me read.
You said that you don't believe that you are biased right now. At some point during the hearing, we go forward on Saturday, and you learn that, you know what, I think I am biased. I think I have prejudged. Which at that point, are you saying that you will raise your hand and say, hey, I can't preside over this anymore because I have just come to the conclusion that I'm biased?
Absolutely.
What happens in that situation?
In that situation, I say that I can't come to that conclusion, that something happened or occurred that I'm biased, but I'm not. I've asked over and over again, let's see the information.
Okay. That's all I have, Your Honor.
Mr. Washington, do I talk to you about any additional person?
Not at this time, Your Honor.
This witness can be excused then. Mr. Cannon? This witness can be excused then.
Yes, Your Honor, and no rebuttal.
Washington? Witness can be excused.
Yes, Your Honor, that's correct.
Councilman, don't take anything down with you. I should have exhibits P1 through P5. If you can bring it up there, don't take it.
Yeah, I give it to the court for,
Watch your stuff as you get down.
thank you.
Yes, officer. Mr. Cannon, call your next witness.
I believe it was the state, that was his witness, so I don't have another witness. I'm closed.
Do you have any witnesses, Mr. Washington?
No, I don't, Your Honor.
All right, so then that closes the evidentiary phase of this. We have argument that he wants to go into. Mr. Cannon, it's your motions. You want to open and close?
I will close, Your Honor.
All right, Mr. Washington, you already did your piece, so this is Mr. Ash's part now.
Yes, Your Honor.
Mr. Ash?
May I ask for 5 minutes to take hygiene break?
Absolutely.
Before we do that?
It's 3:18, you come back at 3:25 and we'll close.
Thank you, Your Honor.
All right, now we'll go right in. It's not open. It's a meeting. It's not open.
No, you're good. Yeah, no, do what you gotta do.
Mr. Cannon, do you have P1 by chance? Mr. Washington, will you see if you have P1 for me?
Oh, this one is right there, I believe.
That's it.
Okay,
You want one? You got some? Okay.
Good afternoon, Your Honor. I have a couple slides that I'd like to hand out. May I approach? So, my role this afternoon, as I mentioned this morning, is to argue specifically the question of what due process actually requires. Because where we started is where we will finish, which is unless the mayor is able to make a concrete showing as an emergency matter of law that Councilmember Gant's conduct up till now has created an impossible procedural due process violation. If she's permitted to proceed in the hearing on Saturday, then he is not entitled to the emergency relief he seeks. So the question then begs, what does procedural due process require of an administrative decision maker in a circumstance like this? There are 4 cases that I would submit to the court that I will go through hopefully quickly that will address that issue. Now I know the first slide, and the first slide is daunting in length, but that's because it postdates Clary and goes into much greater detail, and is from the United States Supreme Court, about what is permissible in the, frankly, frequent circumstance in which an administrative body and a judicial function are combined. It specifically dealt with a Wisconsin Medical Review Board that was investigating a doctor, making findings of fact on the record about that doctor. So the members were making actual formal legal conclusions about the doctor. And the doctor said, well, that violates my due process. It's the same person making the decision that is doing the investigation. They've already, by virtue of the fact they've voted to investigate me, they must, and made these findings of fact, they have made up their mind already. And the Supreme Court said unanimously, no, that's not the case. And the Supreme Court went back to the FTC versus Cement Institute case. That's the middle of this block. Think about how seriously the assumption, the conduct in that case was. The Federal Trade Commission was investigating the cement industry. They had, members of the commission had testified to Congress and to the president under oath that they believed the conduct of the cement industry was violated the law. Cement industry said that they've clearly prejudged this. They can't sit in judgment of us. The Supreme Court said, no, that's not the case. They have testified what their belief about what the law is, what their belief the preliminary investigation has shown, but then you will have an opportunity to have a hearing, and you will have an opportunity to present evidence and make argument to them. That satisfies the minimum requirements of procedural due process. That's the bolded text here. At least some of the members had disclosed their opinion prior to sitting to adjudicate that the system they were adjudicating was itself illegal. The court rejected the argument, unanimously rejected the argument, and Withrow unanimously readopts that holding, saying that the fact the commission had entertained those views as the result of its prior ex parte investigations did not necessarily mean that the minds of its members were irrevocably closed. And here's the kicker. No decision of this court would require us to hold that it would be a violation of procedural due process for a judge to sit in a case after he had expressed an opinion as to whether certain types of conduct were prohibited by law. The court, in reaching that conclusion, made the assumption that every member of the Fair Trade Commission had that view, that the cement industry was engaged in illegal conduct, but said that the fact that you will have a hearing and an opportunity to present to them, to argue to them, to give them evidence they have not yet received yet, that's what due process requires. That the fact that you have said on sworn testimony that you think that their conduct, based on your investigation thus far, is illegal, does not disqualify you. It does not violate due process. 2 unanimous United States Supreme Court cases said that. Further, Withrow goes on on page 56 of that opinion. It's the top of the second page of the slide. It is very typical for members of administrative agencies to receive the results of investigations, to approve the filing of charges or formal complaints, instituting enforcement proceedings, and then to participate in the ensuing hearings. This does not violate the APA, nor does it violate due process of law. Withrow, it's worth noting, the Supreme Court in Withrow explained, in great detail, as your honors read the opinion, our system presumes 2 things. A, everyone has opinions and preliminary conclusions. It is impossible to participate, to hear charges, to hear a preliminary report and not come to an opinion or a preliminary conclusion. You necessarily have to in order to decide what to do with that preliminary report. But B, the system also presumes that decision makers are able to be sufficiently impartial to do their jobs consistent with due process anyway. absent some specific personal bias or prejudice, and that there's a high burden for proving any such specific prejudice, and there's a heavy presumption against it. It's, quote, a much more difficult burden, is what Withrow said. At the outset, let's acknowledge there is a crucial difference between the judicial standard of conduct and what is required by due process, what is required to deny the motion here. The restrictions on you, Your Honor, are enhanced over the minimum of just procedural due process. You have other requirements that apply to you. But what judges are permitted and presumed able to do, even in that enhanced set of requirements, restrictions, illustrates just how far we are from anything requiring Councilmember Gant's recusal here. Every day, you hear evidence, you come to preliminary conclusions, you issue orders about admissibility, about relevance, about criminal warrants, about indictments, about preliminary injunctions, about civil subpoenas, all sorts of things that require you to assess witnesses, to come to a decision about what facts you believe are true, or at least true enough to guide action, and then you issue formal opinions about those things. You tell us what you think. But at no point in the process does you coming to that conclusion and telling us what you think about the facts thus far preclude you from serving impartially going forward. Because you know that there may yet be more evidence to come. There may be more argument, that one of us may say something that flips your mind, and you're able to do that. That, even as a judge, even with those heightened standards that apply to you. But that's what Councilmember Gant deserves an opportunity to do here. I mean, frankly, even sometimes, I'm sure not Your Honor, but other judges, they get things wrong. And sometimes they get overruled and cases get remanded. So they've said something formal as it possibly can be, that that person has to spend 20 years in jail, or that this company doesn't belong to that man. They've said something, they've made absolute final decisions about what they believe, what the facts show, what the law shows, everything. It gets remanded, they're still presumed to be able to sit impartially over the subsequent trial. They're able to do that. And if that heightened standard can be met in those circumstances, darn sure can be met here. Administrative agencies and board members have that same power. They only operate at a lower standard of impartiality. Them investigating, them having opinions about the preliminary facts, the law and how those things mesh, and making comments and findings about those preliminary conclusions is both inevitable by the virtue of the circumstances they're put in, and absolutely constitutionally permissible and does not force recusal. That's Withrow's core holding. That's how it held that a medical disciplinary board could both investigate and enter written findings of fact on core contested issues, and yet still be sufficiently impartial to have a final hearing consistent with the due process protection of the U.S. Constitution. Withrow, it's worth noting, I know Your Honor knows this, but I'll say it, has been approvingly cited and adopted, essentially, by the Georgia Supreme Court on multiple occasions. It underscores that point, that when, as here, as the council members will be tasked to do, when they are tasked with with a preliminary investigation and making comments and findings about those conclusions, they can still sit in the position to decide whether the charges they recommended are ultimately proven. They are presumed to have opinions, but be able to set those opinions aside if the evidence that ultimately comes in and the argument that ultimately comes in convinces them to the contrary. The first time the Georgia Supreme Court addressed Withrow, it did it in Dell Cook Timber, the 1982 case we talked about the other day. That's the middle of the second slide. Here, it says, in order to comply with the requirements of due process, the hearing must be a full and fair one before an impartial officer, a body free of bias, hostility, and prejudgment. The fact that the administrative agency, here the city council, is both the accuser and the judge does not deprive the accused of due process of law, especially where an appeal from the determination of the agency may be had to the courts, just as will be true here. That's Dell Cook. It says even, it goes on to quote, to cite Withrow explicitly, to say even the combination of investigative and adjudicative functions in the same persons in the agency is not a violation of the due process. Then the Georgia Supreme Court did it again to cite to Withrow and to say that it's okay for someone to investigate, to come to conclusions, to even say things that are, shall we say, aggressive or hostile, and be presumed to be able to put that aside and still sit in an adjudicative posture. That was the JQC case in 1985, the matter of inquiry concerning a judge, the 265 Georgia 843. That's the next case on this slide. And at the outset, let me acknowledge that the court was correct this morning when it noted that the JQC no longer has the investigative panel be the same group of people as the people who make the recommendation to the Supreme Court. But in 1995, when this case was decided, it did. And so my point is, when they were the same people who had to investigate, who had to charge, who had to, as the case says, make adversarial comments on the record, that those same people could then be presumed to sit, were then presumed to sit and be able to put their, to be able to have a fair adjudication without being a violation of due process. Again, a citation to Withrow and Larkin. So we know from those three cases that Councilmember Gant's involvement in the investigation, her reaching preliminary conclusions about what it showed, having concerns about what it showed, and why she voted to initiate the formal proceedings, there's absolutely no constitutional problem in her believing that there was enough evidence of wrongdoing to take the next step. That's what she did. To require investigation, to vote to issue the charges. So she's allowed, even expected under the circumstances, to have those opinions and preliminary conclusions. Then what opposing counsel is apparently arguing, necessarily has to argue, is she's not just allowed, that what is actually prohibited is for her to publicly admit she has them. That's what his argument is. It's not that she can't have opinions, because everybody has them. You couldn't sit through a presentation and not have an opinion about that evidence one way or another. You couldn't do that job. It's whether you can discuss them, whether she can tell her constituents what she was thinking when she voted to approve those charges. But that's absolutely not the law either. Remember, Withrow approvingly cited the FTC case, the concrete industry case, in which the commissioners had not just said things on Facebook or in a text message, they'd gone to Congress and given sworn testimony that they believed the system they were going to have a hearing about was illegal. The Supreme Court said that posed no due process issue whatsoever. Unanimously said it in the concrete case, unanimously said it again in Withrow. Withrow also cited numerous examples of situation in which a decision maker investigates, makes preliminary, even serious conclusions in written form, and was still presumed to be able to sit impartially over a contested proceeding to dispute those charges. The JQC case, the 1995 case, discusses the on-the-record adversarial comments made about a judge by the members of the JQC, and Del Cook involves an agency, GDOT, reviewing its own written rulings about whether trucking companies had to pay certain assessments in contested hearings, just as Withrow itself did. So written comments, commentary about your conclusions and about whether your understanding of what you've seen so far violates the law or at least is serious and concerning and merits further investigation, each of those cases say that that's not a due process violation. So the idea that Councilwoman Gant put in writing some of her thoughts and opinions about what the facts so far showed and what she understood was appropriate or not based on that preliminary assessment, and indeed her conclusion that a formal investigation and potential disciplinary hearing was necessary are all well within the broad boundaries permitted by all this case law. And where opposing counsel's argument strays most clearly from existing law is where he started his cross-examination by asking her about the appearance of impropriety. It is an attempt to punish Councilmember Gant for appearing partial because of her public comments on an issue of public concern to her constituents and to stakeholders. But that's not Georgia or federal law. It would be for you, I would submit. You know you can't do that. You can't get on Facebook and talk about this case. But Councilmember Gant is not held to the same standard you are because she's not a judge. She's serving in an adjudicative role, but that's not the same thing. This brings me to my last case. Hyatt versus State. It's a 2016 Georgia Supreme Court case. Here's what it says. It's the third page of the slide. The constitutional guarantee of due process is not concerned with mere appearances of partiality. To the contrary, due process is concerned with actual bias. Absent a showing of actual bias, due process requires recusal only in particular circumstances in which the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. That's Pyatt 298, Georgia at 751. The examples Pyatt gives of what that would be: a direct pecuniary or financial interest, there's been no allegation of that here. A fiduciary role with an organization whose money will be affected by the organization's decision making. You can't own stock, or you can't be the treasurer of a company appearing before GDOT and sit on the GDOT board. A quote, significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case is pending or imminent, or a deep personal animosity caused by a campaign of vilification that created a running bitter controversy. There's no evidence of that here. There's an evidence, certainly. We just all watched that Councilmember Gant can run hot. She can get emotional, but she also can get over it, as she testified to. She also can move on, as she testified to, as her conduct testifies to. We know from Withrow and the two Georgia cases that Councilwoman Gant was absolutely permitted to have opinions, to understand the preliminary evidence, to come to a conclusion about whether it merited charges, whether it merited hiring an investigator, even to come to a conclusion about whether some of the alleged conduct was illegal. There are no due process concerns about that at all. What Pyatt tells us is that it is also okay for her to say those things to her constituents, to say, particularly when, as here, she also made clear that not all of the evidence is in. I know that. I still have a decision to make. It's because saying that I have concerns, saying that I think some of those things are illegal, saying that I think if it proven it would be very embarrassing. None of that indicates she's made her mind up on the ultimate issue. It would violate likely a judicial code of conduct tenet. It does not do so in the reduced standard when all we are talking about is the procedural due process requirements, and you know that because of the facts of the Withrow case and the case it relies upon. That's the core difference between what you're tasked with every day and the burden on Councilwoman Gant and her colleagues. So long as she doesn't harbor actual undue bias, no financial motive, for instance, then she can, indeed has to, by virtue of her role, have opinions about what she's learned and speak about them. And that's all she's done. She's engaged with her constituents and her Stockbridge stakeholders honestly and transparently. She's been the one willing to say, why are we going through all this? Because there's a lot of stuff out there and we got to get to the bottom of it. And it's a mess. And I'm concerned and I'm frustrated and I'm mad. And all of that is true, and none of that suggests that compels the conclusion she's already made her mind up and cannot sit. Not in comparison to all of the things that happened in Withrow, in Del Cook, in the JQC case. They are asking that she be punished and the subject of a sanction for being willing to be candid with her constituents, that she has concerns, and that's why she voted for a formal investigation. To disqualify, which is really what they're asking for. They're asking you to hold as a matter of law she cannot participate. That's a very serious finding, particularly where an attorney is involved. And we're nowhere near that. Not when you apply Pyatt and exclude the arguments about the appearances of partiality. Nothing here gets close to what would compel that. I mean, the Lewis text messages that we went through in painful detail earlier, that she wants to sort it out, that she had love for him, that she was trying to protect him. Let me pull him up. That we sort out all of what was given to us. That needed to happen to know how to proceed. That with the mayor's grandmother, she said, I was just trying to dilute the outcome of what could be disastrous if the allegations are true. If the allegations are found to be true, exposed, it could ruin him. He should let the investigation do his job. If just know, I wouldn't come to you if I truly wasn't concerned about the end result could turn out. Those are not the statements of a woman who's already made up her mind. Those are the statements of someone saying, I've heard some really serious stuff. I've got concerns. That's why I voted to move this thing along. But she's allowed to do that. If an FTC commissioner can go to Congress and say what they're doing is illegal under sworn testimony, and that doesn't violate due process, then she can say the investigator needs to do his job, because if those allegations are true, they're real serious, because they are real serious. That's not an undue bias. That's an acknowledgement of the fact that serious charges have been leveled against him. Her comments in context in her testimony today establish that yes, her emotions run high sometimes. And she's had concerns, and she believes that there is enough evidence to proceed to from the initial stage to a formal investigation and charges. She's still waiting to hear the results of the investigation. She said that over and over in all of these Facebook posts. Willing to listen to the evidence and the arguments, and to listen to what the mayor, when he finally puts up evidence of his own, and what his lawyer will put up as evidence of his own, and see where all that sorts out. She's done nothing wrong here, let alone enough to establish a basis to enter an order that would effectively disqualify her, even if the court moves past all of the issues, the procedural problems with where we are, that Mr. Washington raised this morning, that I presume the court remembers and would prefer I not go back into at this point. At that point, unless the court has questions for me, I will yield the microphone. And I thank you for your time.
No problem. Yeah.
To have City Yard, but I'm not going to go through all this for the court to consider consideration. And basically, what I have done is I have matched and mapped out all of the statements made by Councilwoman Gant to each of the charges. Okay, what counsel is talking about in those other cases are situations where someone have not patently demonstrated bias or prejudgment. In other words, these individuals may have said these things need to be investigated. The Pike case he's talking about, oh, they're down there doing something illegal, but you don't have these individuals who are charged with the responsibility of being the fact finder to determine whether the mayor should be removed. And out there making comments basically saying, I believe what has taken place. She even in her text messages, and not just text messages, but in her Facebook, talking about she has receipts. She has made herself a witness, pretty much, because she is testifying, basically saying, not testifying, but she's basically saying that I know for a fact that he did these things. So therefore, if you know for a fact that he did these things, how can you be fair? How can you be impartial? Because if he gets up there at the hearing and says, I didn't do these things, then she's going to say, that's a lie. I know for a fact. So she has inserted herself, not just as a role of the decision maker, a neutral decision maker, but a person who has demonstrated to be biased and who is prejudged. One minute, you can say all day long, oh, but let the investigation go on. But at the same time saying, I would not have him around my child. At the same time saying, he doesn't need to have initiatives. He doesn't need to be around children. At the same time, accusing him and believing that he committed these crimes, or they would be crimes because they were trying to say that they were children. At the same time, after she became a decision maker, pursuant to the resolution, she's out talking about the facts, the evidence, the investigation, what someone has told her. She did it now she didn't want to admit the conversations that she had, the statements that she made to Emmanuel Jones. But it's very ironic that after she and Mr. Alexander spoke with Emmanuel Jones, there was a letter to the governor saying that the mayor should be investigated for sexual misconduct. So you can say all day long, I am not biased. There is a reason, Your Honor, that they are hell-bent on keeping Councilwoman Gant on the panel. when you have all these opinions and people are saying we think you're biased and based on your statements, and she's saying she's getting all these pressures from the people in the community, and you've made these comments, why not just step aside? Because what they're saying is, well, if she decides during the hearing all of a sudden that I'm biased, then I'll raise my hand and I will recuse myself. We know that's not going to happen. She has no intent of recusing herself. They're saying, well, even if she is biased, let the process go along and then allow the mayor to appeal afterwards. But that's not how that goes. The case law, I'm not going to go through the case law because the court already is very thorough in understanding the case law. But that's not how that goes. He is entitled to a panel that is fully fair and impartial. The problem is that she will never say she's impartial. She will never admit that she's biased. And there's no mechanism that the city has in place to deal with that. They're not addressing that. They're talking about, because he has a constitutional right for due process as a mayor. He has a property right in that position. So when you're trying to remove someone, and there's an allegation or there's evidence, this is not just allegation, there's evidence, strong evidence, not just small, this is not appearance. This is not the appearance of impropriety. The facts and the evidence show that she is biased, whether she wants to believe it or not. But the problem is, Your Honor, just like in those other cases, a Clara case, there's no mechanism to challenge it. Because what if she says, yes, I'm biased, yes, I'm impartial, yes, I'm going to find that he should be removed, I don't care what you guys say. Who's going to challenge it? So what do? You let the system go on and let her stay on the panel knowing that she's biased? They put in their own statement of resolution or so, the procedure that if you are biased or impartial, you have a right or a duty to recuse yourself. But what's missing is, what if she doesn't? Who decides? And that is a failure with the charter. Other cities have mechanisms in place. I don't know why Stockbridge doesn't, and maybe they'll do it after this. But other cities have mechanisms in place just in case there is a person on the panel who may be biased. So they may have the ethics board, they may have some other type of panel say, okay, let's receive this information, this evidence, and let's make a determination. A fair board make a determination. They don't have that here. So what they want to do is say, let's disregard that, Your Honor. We don't care anything about that. But why are they so hell-bent on having her on that panel? All she has to do is say, you know what? I'll remove myself. I want to show everyone that I'm not biased, because they want to ram this thing. Listen, they violated his right, the charter, by hastily trying to schedule it on a Saturday without giving him notice, written notice. And then she says, well, it doesn't matter, it's just oral. So she's not even following the charter. So then there's a reason why they wanted to have a hearing to oust him before our August 17th hearing, because they didn't want it to come to you. They didn't want him to be reinstated. They have no intentions of reinstating him. They have all the intentions of removing him. But if you want to have full transparency, and you're talking about full transparency, then do the right thing and just recuse yourself. Then everybody will think, okay, well, you're on the right track now. They still have 4 other council people, but there is a reason. She knows what she's going to do. She's already made up her mind. We don't have to sit here and wait for her to do it and to be surprised. So, Your Honor, I've given the court a map. You can look at where all these statements that she made. Again, she's talking about the vehicle, and this is all in Facebook. Hey, please return your vehicle before it gets out. And she is disseminating text messages between herself and the mayor just to prove her point. She's disseminating this to the community, and she's supposed to be the arbitrator. Now, what if the court did that? What if the court said, you know what? Now he talked about, oh, well, the judge, you can't do certain things. No, of course you can't. You can't get on Facebook. And the difference is that, Your Honor, you're not getting out in the public talking about a defendant is not being the victim. It's not the victim. You're not sitting here and saying that, oh, I've got this case in my courtroom and this guy's bad. We got to get rid of him. I would never have him around my child. When you're sitting as the presiding judge, and incidentally, Your Honor, he's trying to say that because she's not a judge, she's just a lawyer. Well, she is a quasi-judicial role. That's what the court said. That's what the case law. She's quasi-judicial. That's why we're here before this court, because you have the jurisdiction when it's quasi-judicial to invoke equity, to make sure that due process is dealt with. And incidentally, Your Honor, we did serve the Attorney General pursuant to the statute, because this is a constitutional issue. It's constitutional because he has a due process. He has due process. And you can't just trample over his due process and say, okay, well, we'll deal with it later. So I'm going to sit down. I think the court is well aware of the facts, well aware of the law in this case. I think that we're not asking the court to remove her from being a councilwoman. We're not asking that. What we're asking the court to do is enjoin the city, very simple, enjoin the city from allowing Councilwoman Gant from sitting on the panel. Now, you can even do it temporarily, Your Honor. You can do an interlocutory, and you can do it temporarily until they comply and have some type of mechanism in place. You can also enjoin her, and they can still have the hearing on Saturday because they have 4 other council people that can make a decision, and they have a quorum. So I ask the court to follow Clary, City of Ludowici, Your Honor, City of Macon versus Anderson, and grant leave to supplement the second amended verified complaint, as well as enjoin the city based on our emergency interlocutory motion to enjoin the city to prevent them from allowing Ms. Gant to sit on the board and preside over this case.
Thank you so much, Mr. Cannon. Pursuant to OCGA 911-15D, that motion is denied, and that means the filing that came with it was not a proper filing, since the leave was not granted. The August 6, 2026 plaintiff's emergency motion for temporary restraining order, emergency stay of August 15 hearing, and temporary restoration of mayoral authority. Most of the issues in there are largely new because they were covered by the consent agreement, but to the extent that they relate to the issues that we're here for today, I will find that looking at the Clary case even and relating that to the resolution, you guys did not look at resolution evidence, but it was part of both of your filings, and so I'm looking at resolution number R26-1961, and under section 5 of that resolution, it reads, the City Council hereby requires that a neutral party shall, as hearing officer for the investigative hearing, the hearing officer is appointed solely to conduct the evidentiary hearing in a fair, impartial, and orderly manner. The hearing officer shall not participate in the council's deliberation or vote upon any matter before the council. counsel. On commencement of the investigative hearing, the hearing officer shall have authority. The first one says maintain order, the second says rule on procedural matters, and it is my finding that ruling on a procedural matter, a motion to recuse or rise from one council member would fall there, and therefore the mayor does have an adequate remedy of law such that it does not trigger my involvement as a court of equity, because the resolution provides first for a remedy for the mayor to challenge the ability of one of the adjudicators to sit on the matter. That will be the order of the court. I will file an order for you, maybe tomorrow. We will, I think that takes care of all of the outstanding stuff that I have. I have all of the exhibits as well, and so that will conclude this matter.
Your Honor, could I just go to the record,
Go ahead.
that I will be filing a motion to stay the entry of the order pending an appeal.
Entry of which order?
Well, I'm asking the court to, since the court is going to deny it, I'm asking the court to stay the hearing on Saturday to allow me to be able to appeal the court decision.
You want me to rule on that now, or are you going to file something you're saying?
I can file it. I can file it, well, it won't be today, but the problem is that it's on Saturday.
Okay. I'm not going to grant an interlocutory appeal in this issue because I don't think that there is an issue that is unclear legally that we need the appellate courts to weigh in on. The case law is fairly clear that if there is an adequate remedy in law, it does not trigger equity. The argument that you guys have made essentially is that the procedures as they are currently set out for the hearing on Saturday does not provide the mayor, as your pleadings indicate, did not provide the mayor with an adequate remedy in law to handle the issue of a recusal of the councilwoman. And what my finding is that the resolution does, and I do find that that is in line with the case law, and so that does not, for me, rise to the level of granting an interlocutory. So you can file it, but I can just do it orally and tell you that I'm not going to issue that, without me saying that work. Mr. Washington, anything that you want to put on the record?
No, ma'am, Your Honor.
You guys take care of the court reporter, and then you can have a good rest of your afternoon.
Thank you so much, Judge.
And I will try to, Mr. Kennedy,